Getting it right.
We are now on the record officially, everybody. Thank you. Maria?
Welcome, everyone. I'm Maria Volpe. I'm a professor at John Jay College at the City University of New York, where I also direct the dispute resolution program. This monthly roundtable breakfast is co-sponsored by the Association for Conflict Resolution of Greater New York and the CUNY Dispute Resolution Center at John Jay College of Criminal Justice. Each month, these breakfasts are made possible by a wonderful committee of facilitators and organizers, which includes Matthew Latimer, Nikki Borofsky, Sherston Pugh, and Chloe Choi. These breakfasts, as you heard, are recorded. We do post them on the websites of the co-sponsors, ACRGMY and the CUNY DRC, and they are on YouTube. If you search for NYC-DR breakfasts roundtable, you'll see them pop up on YouTube. Sherston, I know that you wanted to make a quick announcement for the ACR GMY conference, which is going on. Our co-sponsor has a wonderful event going on. If you could say a few words before we get started here.
I do. Thank you, Maria, and good morning, or wherever you are in the world. Thank you so much for joining us today. Right now, we are midway through the ACRGNY's 24th annual conference. The vast majority of the conference is virtual, and we actually have some presenters I see who are on the call. So congratulations to them, and thanks for being part of their conference. It is still not too late to register. There is a wonderful program happening today and tomorrow. But also, if you're in New York City or the area, this evening at Cardozo Law School, we're having an in-person event. It's free for members and $10 for non-members. So I just put a link in the chat, and I'll also put a link to the conference agenda as well. So we hope to see you there. And for those of us who have been joining us this week, thank you very much, and we hope you're enjoying the conference. Thanks, Maria.
Thank you. For those of you who are curious, next month's speaker will be Jim Malamed from Mediate.com, who will be talking about AI-related matters. So put it on your calendar, and it will be July 10th, since the 4th of July is going to interfere with our first Thursday of the month gathering. By the way, this month is our 288th roundtable gathering since I started these after 9/11. This morning we have with us a wonderful colleague who I've known, it seems like forever, Nancy. It's been just phenomenal to see how this field has grown. We could not have imagined this kind of gathering way back in the day when we always looked forward to meeting each other face to face. We would never have been able to connect with people from coast to coast and around the world on the first Thursday of the month. You had to come to New York since 2001, but before that, we were meeting all over the place. It is really terrific to have you here with us. Nancy, and I am going to turn it over to Nikki, who is going to do a more formal introduction of our presenter this morning. Thank you again for joining us, and look forward to the morning. Nikki?
Thank you, Maria. One of the great things about this forum is that we get to meet everybody's great, talented, brilliant friends. And so I put that out before I introduce our speaker today as just a recommendation to everybody to let us know who you think we should be listening to. So I have the very difficult challenge of introducing today's roundtable breakfast speaker. Our speaker is Professor Nancy Welsh, and just listing her titles is going to undersell what she's been up to for the past decades. She holds the Frank W. Elliott Jr. University Professorship at Texas A&M, although she's calling in from Michigan today. But she directs the Aggie Dispute Resolution Program. She is a past chair of the ABA section of dispute resolution and a longtime co-author of one of the field's leading textbooks. What's really relevant to us this morning is that she has spent years asking very difficult questions about mediation, especially about what it becomes once institutions, courts, and legislatures get involved. She has written more than 70 articles and chapters exploring how values like voice, procedural fairness, and self-determination actually play out, not just in theory, but in courtrooms, at agencies, and all the legal workarounds that we've created. She has warned persuasively that when mediation is pushed too far towards efficiency or risk management, it risks losing the very things that make it meaningful. You might be reminded of Doge's efforts. Efficiency can have lots of different effects. She's author of she's also the co-editor of Evolution of a Field, a book of personal essays by dispute resolution pioneers, which, if you haven't read it, get it. It's actually a free PDF you can download, and it's really, really inspirational. Her own chapter, Crosscurrents, stands out, and it's a thoughtful reflection about how gender, institutional incentives, and procedural design intersect and sometimes clash in the evolution of our field. Today, this morning, for some of us, Nancy will take us into territory that's both nuanced and pressing. Her talk, Opportunistic Distortions of Mediation, asks us to pay attention to places where well-meaning policy choices may be bending the mediation process into something else entirely. Whether it's drive-by mediation in Texas, which you'll talk about, binding mediation in California, or the use of confidentiality as a litigation shield, she's going to challenge us to consider when a process that promises fairness might be used to preempt it. So, if you've ever wondered whether the field you love is quietly being reshaped into something else, if the Singapore Convention's promise of global mediation comes with some fine print that we should be taking a look at, we are in very good hands today. Please join me in welcoming Professor Nancy Welsh. Please feel free to pop your questions into the chat, but hold until the end where she's really going to engage in Q&A. But also keep your eye out for sections of the presentation where you'll be asked to engage and do so. Nancy Welsh, Professor, the floor is yours. Thank you so much for joining us.
Oh my gosh, what a wonderful introduction. I feel known in an incredibly affirming way. I really appreciate it, Nikki. Thank you very much. Also, thanks so much to ACR, the Greater New York chapter, and to John Jay for allowing me to be part of this. I also just want to do a shout out to Maria, who, yes, we have known each other for a very, very, very long time. Maria is one of the foundational thinkers and doers in the field of dispute resolution. That term pracademic, does anyone use that term anymore? It absolutely fits Maria in so many ways. And also this listserv, and also these roundtables have played such a wonderful role in terms of keeping people informed regarding what's going on in dispute resolution, and developing a sense of community. So thank you so much to Maria for these sort of organizational efforts, as well as her thoughtful work in terms of the use of mediation in a variety of different contexts, including very difficult public disputes and issues regarding diversity. All right, so thank you very much for inviting me. I appreciate it. I'm about to put up my slides, but before I do that, I just want to say one more thing. So I am a big believer in mediation. I have been a big advocate for mediation for a really long time. And so what I'm going to be presenting is going to involve some of my concerns about mediation. But what I want you to know before I begin is that I'm coming from the perspective of somebody who really loves this field and sees such potential in it, and then gets very upset when I see things happening. So I'm coming from the perspective of one of those difficult people who, is always worrying, and I'll be looking very much forward to your questions and also to our conversation. I suspect that some of you will agree with my worries and some of you won't. And I really want to hear from you. This presentation that I'm making is part of a manuscript that's not yet published. So the kinds of things that you share with me very likely to affect some of the revisions that I make to that manuscript. So I'm looking forward to this being a very participatory sort of session. All right, so let me go ahead and share my slides. All right. So let's make sure that they go forward. Yes, that's good. All right. So here's the organization that I planned for today. So first of all, I am going to say a little bit about what I am talking about and what I'm not talking about. Okay. Because it's very tempting, I think, potentially to get into old debates as we have the conversation today. I don't really want to deal with old debates. These are new debates. I'll then be sharing with you a few stories of what I call opportunistic distortion of mediation. Maria has already referenced some of them. I'll be talking a little bit about their potential relevance in terms of the Singapore Convention, and then a little reflection on acknowledging what are some of the benefits of these variations, because there are some benefits to these variations, which I am calling distortions, right, which is normative, but could also be called variations, which would be much more nuanced. And then what are some of the problems associated with them? What would be some potential responses to deal with them? Although I will allow the largest amount of time for Q&A at the end, I also have built in various points along the way where I'm basically going to be turning to you and asking, so what do you think? Talk with me. And I look forward to those conversations. All right, so let me begin with what I am talking about and what I'm not talking about. So I am going to be talking about the process of mediation as one in which that concludes these particular elements, that there is an impartial third party, that third party facilitates communication and negotiation between the parties, and the third party assists those disputing parties in reaching a voluntary agreement regarding their dispute. That seems to me to be a pretty straightforward definition of the basic elements of mediation. I have recently added a third element, which is or a fourth element, which is do no harm. I'm not going to deal with that today. But I also want to be really clear about what I am not talking about. So I'm not going to be talking about or contesting the idea that mediation can be a process that still deserves to be called mediation, even if it's largely characterized by reality testing, evaluation, or even a mediator's proposal, which goes to the parties. I'm also not going to be contesting mediation that is conducted entirely in caucus rather than in joint session. I know that these are variations that are of concern to many people. They are not the subject of today's conversation. What am I going to be talking about? Those 4 different stories of mediation. And then their significance potentially for the Singapore Convention and what maybe we should be doing. I'm going to start with the story of drive-by mediation, a form of mediation that I have to say has a great name. So what is it and how did it come to be? So in describing what it is, I have to begin with its history. In 1987, Texas, which is where I teach, that's where Texas A&M is, was one of the very first states to adopt an ADR Act. One of the very first states to give courts in the state the power to order parties into mediation and other dispute resolution processes. It was possible to use mediation for all different sorts of disputes. Among those were family cases. But then in 1995, the Texas legislature actually made mediated settlement requirement binding upon the parties and entitled anyone using mediation to resolve issues regarding child custody, so the parent-child relationship, entitled anyone using mediation to reach an agreement on those issues to judgment by the court, even if the court didn't agree with the arrangement that the parties had entered into. What does this mean? It means that if parties used a mediation to reach an agreement, that a judge wouldn't be able to undo that agreement. The judge had to incorporate it into the judgment, even if the judge didn't think it was in the best interests of the child. That's pretty revolutionary, because overwhelmingly in the family area, judges do need to review parties' agreements to determine whether the judges think they are in the best interests of the children. There were concerns that were raised about this statute. I will say that one of the reasons the statute was adopted was really to encourage the use of mediation in the family area. And the reason that the legislature thought they needed to encourage it was because there were parties who were not using mediation. Why? Not necessarily just because they were unaware of mediation, but because they were worried that a judge could undo the settlement agreement they had reached. And also, they were worried that if one of the parties to that agreement decided, I don't agree to it anymore, they could essentially revoke their agreement. This statute that the legislature adopted in 1995 took those away. No longer could you revoke the agreement that you had reached, and no longer could a judge undo it through a consideration of best interests of the children. There were concerns raised, though, that these mediations in Texas, that they might involve people who were subject to intimate partner abuse, and that they might enter into agreements because they were afraid not to. The legislature amended the statute in order to provide a tiny bit more discretion to judges, that judges might be able to refuse to enter judgment on the parties' mediated settlement agreement if the judge found that one of the parties to that agreement was the victim of intimate partner abuse. They had not really been able to engage in negotiation, and also the best interests of the children were not met. So I want you to notice all those findings the court had to make in order to be able to refuse to enter judgment on the agreement that had been entered into by the parties. A few years later, along came a case, In re Stephanie Lee. This was a case in which the parents of a young daughter had entered into an agreement for the child custody and visitation that included the opportunity for the daughter, to spend time with the mother, even though the mother had married a registered sex offender. I think it should be pretty obvious to all of us why there might be concerns about that. The father had agreed to this. The father had signed the mediated settlement agreement. But the associate judge who was responsible for reviewing the agreement and incorporating it into a judgment raised concerns. During that colloquy, the father decided he no longer thought it was a good idea for his daughter to be able to spend time with the mother under these circumstances. And so he objected. Remember, he didn't really have the opportunity to object under the statute, but he objected. And the associate judge, despite the statute, decided that the judge was not willing to enter judgment consistent with this agreement. It was appealed. On appeal, the appellate court affirmed the trial court judge. It goes up to the Texas Supreme Court. Texas Supreme Court decides, no, actually, we are going to enforce this statute. The words of the statute do not provide the judge with the ability to refuse to enter judgment, and this is a mediated settlement agreement, and therefore the judge must enter settlement on this. So what have we just talked about? We've talked about the particulars of the statute. We've talked about why the statute was adopted and what advantages it provided to the parties. It allows them to avoid judicial review. It allows them to gain enforcement of the power of a judgment. We see that In re Stephanie Lee challenged that, but In re Stephanie Lee ultimately decided to affirm the statute. Now, I will say that there's language in the Supreme Court's decision, both in the portion that is joined by the majority and also in the portion that represents a plurality decision, that helps to explain why the court would have been so deferential to a mediated settlement agreement. A big part of it is because that's what the statute said. But another part of it was that the court concluded that mediation offered special benefits in the divorce and child custody area when it came to the care of the children. Here are a couple quotes from the majority opinion. Encouragement of mediation as an alternative of dispute resolution is critically important to the emotional and psychological well-being of children involved in high conflict custody disputes. The legislature's choice to defer to the parties' best interest determination in the specific context of mediation recognizes there are safeguards inherent in that particular form of dispute resolution compared to various other methods of amicably settling disputes. Now, if you and I think about our general image of mediation, and perhaps the image of mediation in which parents are in the same room, a mediator is facilitating their conversation and their negotiation. Mediator is helping them hear each other, understand each other, work together to come up with something that's in the best interest of their children. Absolutely. You can see how a court decision would include this kind of description of mediation's benefits in this particular context. After the decision in re Stephanie Lee, the legislature actually went back to the statute and amended it to include one more circumstance under which a judge could refuse to incorporate a mediated settlement agreement into its judgment when it came to child custody. And that was if one of the parents was a registered sex offender or otherwise was acknowledged as somebody who had engaged in sexual abuse. But still, that's a pretty narrow. I want you to again notice a judge can only refuse to incorporate the terms that the parents have reached into the court's judgment if the judge finds sex offender or victim of intimate partner abuse, and it's not in the best interest of the children. Still pretty narrow, right? What else happened after the legislature had adopted its amendment? Well, we saw the rise of something called drive-by mediation. What is drive-by mediation? Now's finally the time that I will tell you what it is. In drive-by mediation, lawyers represent clients in a very traditional way. They negotiate with each other on behalf of their clients. Presumably, they're talking with their clients in the background, but this is traditional bilateral attorney negotiation. And then after they have reached an agreement on behalf of the parents, a negotiated marital termination agreement that includes child custody provisions, they then call a mediator. They call a Texas mediator, and they say to that mediator, we need you for about a half an hour. And we'll get together with you online and we'll be there. The lawyers will be there. Our clients will be there. You, the mediator, will be there. We will have sent you the negotiated marital termination agreement in advance so that you can see what it says. And you'll get on with all of us. And, you can ask the parents, do they agree to these terms? And they'll say yes. And then we'll be done. And you can send to us the termination agreement through DocuSign, and we'll all sign, and we're done. And if it is blessed in that way by the mediator, then it is considered a mediated marital termination agreement. Okay. Does that sound like the mediation that the Supreme Court of Texas was assuming was engaging, that the parties were engaging in, or that the legislature probably assumed the parties were engaging in? I would suggest not. Um, and if you're thinking to yourself, oh, this must not happen very often at all, or the mediators or lawyers who are engaged in this, they must try to keep this a secret because it sounds so inconsistent with what mediation is supposed to be. Think again. If you go online, you will quickly find both lawyers and mediators who are willing to talk about their engagement in drive-by mediation, and some of the language that is used includes stuff like this. It's mediation on fast forward, analogous to cruising through a fast food drive-through when, for example, you don't want to spend the time or money that is required to go to a sit-down restaurant. It's only offered for cases that already have a full settlement, requiring only a mediated settlement agreement to formalize the party's existing agreement. There are mediators who specifically say we schedule these sessions at 8 a.m. or 6 p.m. They may last only 30 minutes, and the sessions are conducted exclusively via Zoom. Okay, so my question for you, I think, at this point is this mediation? Do you think this is mediation, or does this represent an opportunistic distortion of the process that resulted from the legislatures and the Supreme Court's belief in the value of mediation, encouragement of its use, and finding a way to reward and incentivize those who used mediation? This is an opportunity for me to hear from you. If you could use the raise hand function, if you'd like to weigh in at this point, I'd appreciate it.
So welcoming everybody to use their raise their hands. There's already been one comment that says, I hope that mediator has very good malpractice insurance. Jeremy?
Hi, Jeremy. I meant to say, very nice to see some folks online that I haven't seen in a while, and you are in that category. Very nice to see you.
It's great seeing. It's fascinating. Texas has always been a really an interesting place to observe in the evolution of mediation. Look, it's a very difficult issue because I look at mediation cross-border in different jurisdictions. And I think we've got to understand first, what's our definition of mediation? Because I think we have the problem in a bit of, the analogy I give is like the 16th century Protestant Reformation. We all have our different views of the church and what mediation should be. And then we get shocked when other people do not understand it or interpret it the same way. But let's take the International Mediation Institute's definition of mediation, which was the only one that it could come up with, which was a universally accepted one. It is that mediation is facilitated negotiation with the help of a trusted neutral. If I look at what you've described, there is a negotiation. Was it facilitated as it was being reached with the help of that neutral? You could argue that their absence in the room makes it not the case. But if there is an adequate summary of the issues in that half-hour session, if the half-hour session is properly structured so that the contentious issues are highlighted, presented, the logic of why they were resolved in a certain way, just thinking with a legal hat, using a definition, I could understand why somebody might say this is mediation. You facilitate an outcome with the help of a trusted person who's there, who's neutral, independent, and impartial. We're assuming that the person is neutral, independent, and impartial, by the way. Okay.
And assuming some engagement by the third party with the parties to the dispute. I will just add, Jeremy, we are going to have a chance to consider, for example, whether something like drive-by mediation could be used in, let's just say, international commercial cases, which then could be entitled to expedited enforcement under the Singapore Convention. So the kinds of things you're saying, absolutely.
But I
Yeah,
was actually going to put
absolutely.
this around the other way, because one of the
Yeah,
things that we are seeing
yeah.
is taking a mediated settlement agreement and converting it into consent award and arbitration.
Oh,
Um,
absolutely.
and so there is no
Yeah,
mechanism for that. So let's think about what is happening currently in arbitration.
yep, yep,
People are saying, let's negotiate a
yep,
settlement, let's reach a settlement, we'll sign it. Let's
yep,
now find the poor unsuspecting arbitrator who's
yep.
agreeing. Was there even a case in controversy when the case is brought to them? So let's set aside, let's assume the arbitrator was appointed at the very beginning.
Yeah, yeah,
Okay, but they're there,
yeah,
and you go to them and say, look, your job is in half an hour, we're going to explain to you what is going on here. And your
yeah,
job is basically to listen to us and endorse this so we can convert it into consent award. I
yeah,
haven't seen anything on what is the role of an arbitrator in these situations. And I think it's a
yep,
very similar one. So while
yep,
I'm extremely uncomfortable with what you've described, because I'm now referring to my own religious beliefs in mediation,
yep.
um, I have a difficulty throwing it all out the window if there is due process, even within that half an hour process.
So let me just say, first of all, you're absolutely right about, I think, the analog of consent awards in the arbitration context. Absolutely. When we get to the discussion, the further discussion of the Singapore Convention, let's come back to this, because one of the things I'm assuming in general is that when there is the conversion of a mediated or negotiated settlement agreement into an arbitral award in that context, I'm assuming in general that there's an arbitrator in the picture from the beginning, rather than an arbitrator who is only called upon after the agreement has been reached. But let's hold, yes. Okay. So what I'm letting you know is the question I have for you, I think. One last thing before I then turn to Jung Hoon, who I hope I'm saying your name right. One last thing in connection with this. Interestingly enough, since I started focusing on this, and actually since I wrote a manuscript in connection with it, there is a former associate judge in Texas who has now actually written an article that's in the Texas Bar Journal extolling the praises of drive-by mediation. He's a former associate judge, now mediates and arbitrates. And his description of drive-by mediation suggests there is not any colloquy, right? Because he calls it just rubber stamping the settlement agreement that's been reached. Again, we'll come back, Jeremy, I promise. Go ahead, Jung Hoon.
Hello, Professor Welsh and everyone
Hello.
in this call. My name is Jong Hoon. I'm an attorney in New York. I thought about this question. Very, very interesting discussion. So really appreciate it, Professor Welsh. But I thought of it using the 3 points that you started the presentation with. So mediation having the element of impartiality, facilitated communication, and voluntary agreement driven by parties. Um, so sort of going through that list, with the first one, I didn't see a lot of impartiality at work because it sounded like parties are represented by their attorney and then mediator just sort of sign off on the agreement. So I didn't see a lot of sort of dialogue that's taking place with a third party, neutral, impartial mediator. So I don't think that element is satisfied. Facilitated communication, I think we can say that element is probably satisfied because you have attorneys sort of helping, hopefully listening closely to their clients and also negotiating terms. So I would say facilitated communication. I'll do a check mark on that. Last one though, I think this is where this element of sort of voluntary agreement driven by party would uh, for me, it would sort of be the element that decides whether this is a mediation case or an opportunistic distortional process, because every attorney-client relationship is a little bit different, where sometimes attorneys sort of drive the process and really proactively advise client, and but sometimes parties really are very active and get involved in the process. I think that sort of depends on how involved each party in particular case is. So again, I think impartiality not there. Facilitated communication, yes, but the third element of, whether it's voluntary agreement driven by party, I think that's sort of the one that's going to decide this
Very
question for me. Yeah.
Very interesting. Thank you for sharing that, Jung-Hoon. It's a different assessment than the one I engage in, but that's part of why it's exciting to have this conversation with all of you. Leslie.
Thank you very much for this very fascinating, actually, discussion. I look at this more politically, actually, where I see a state where parents have a huge amount of discretion with children in a way that other states may not. And it bothers me enormously that there is nobody there to represent the child when, there is so much child abuse. And we see it a lot. I see it a lot in New York. I see it a lot all over. Now, I have to say, though, that in other areas of the law, this may be perfectly fine. And there can be negotiations. For example, I do a lot of personal injury. And if a situation is where this is all negotiated out and you're just going to have a mediator sign off on it, I don't see that there's necessarily a big problem with that. But when we're talking about custody, or maybe even a separation agreement, this is just an enormous problem to me, and one where children's rights are affected without any representation. And I just think, well, it's Texas, and
Well,
that's the way it is. Texas, Florida, that would be, where that would happen more. And it's disturbing to me.
So since I teach in Texas, I want to say one thing that is pro-Texas, and that is so I used to be at Penn State before I came to Texas A&M. And I will say I had all these stereotypes about what Texas was. And actually living in Texas, it's a much more diverse, complicated state, than you realize until you get here. And here, I'm in Michigan right now, but here. The other thing is that it is very much, I would say, Texas, a can-do kind of state. And I think in a way this fits in the category of can-do in a way that I don't like. I mean, a can-do spirit can be really wonderful, creates opportunities, but it also can go too far. One last thing in connection with what you're saying. I want us to remember as we're looking at this, that the statute and the Texas Supreme Court privileged mediation and mediated settlement agreements in a way that it did not privilege negotiated settlement agreements, right? Right? If it was just a negotiated settlement agreement, then you were not entitled to this kind of hands-off approach from the judge. So if I think about it, you raised the analogy of personal injury. And I mean, I think I agree that in general, courts should allow the agreements that have been reached to resolve personal injury cases. They should allow those to go forward with. And I think in general, number one, those kinds of agreements don't require judicial approval in most states. They're allowed to be settled. And then I think research that Jim Coben has largely done shows that if one of the parties then refuses to comply with the agreement they've entered into, overwhelmingly courts will enforce those settlement agreements, overwhelmingly. But they still don't have to. And that's what's different with this statute that it is giving a special privilege to a mediated settlement agreement as compared to a negotiated settlement agreement. And now, in a context where I agree with you, it makes sense for judges to have the ability to peer into it and determine whether or not the child's best interest is being met. In this context, the courts are being deprived of it. All right, so I see one more hand up. And this I am going to say is going to be my last hand I'm calling on before moving on in order to be sure I come within the time limits that we have. Michael. And yeah, I hear you. Yeah, go ahead.
Part of the challenge of determining is this mediation is that in Texas, we're right now probably taking a somewhat mature or applying a somewhat mature lens to something that evolved at a very immature time in mediation. Back in the 80s and 90s, Texas was one of the leaders. Ohio was, I think, far ahead of Texas still. But Texas was one of the leaders in trying to develop mediation as a practice.
Yeah.
And back then, anybody who could print up a business card saying I'm a mediator was a mediator. And there was no clear definition of what mediation was. And that existed for a very long time in Texas. Now, I say that based upon my personal experience. I moved to Texas after law school in 1982, and I spent the next 20 plus years there. I was on the early ADR committee for the state bar. I helped lobby the legislator for early legislative activities of mediation, worked with Judge Frank Sanders, who was, the icon of Texas back then, developing a lot of the legislation. But there was like hardly, it was really, the Wild West of mediation back then. And so they've layered on since then these constructs of mediation that are built on a very somewhat possibly less than perfect foundation. And so now when we ask, is this mediation? I think that it maybe needs to be viewed in the context of a somewhat imperfect system in Texas that it is attributable to the early days when mediation was anything and everything you called mediation.
So great points. I will say though, and I'm sure you know this also, really in the United States, there is no state that has any particular sort of licensing or certification requirement for somebody to be able to hold out a shingle and claim to be a mediator. That's different if it's a court-connected mediation, if you've been appointed to mediate a case by a judge, then there are many courts that have requirements regarding who can claim to be a mediator. But I think the Wild West it's not just in Texas, actually. I think it's in many parts of our country. Let me just say one more thing. I'm going to say a little bit more about this later in the presentation when we talk about the benefits, arguably the benefits of these different opportunistic distortions of mediation. But I have had the opportunity to meet really wonderful mediators in Texas who practice in the family area and in other areas, as well as really wonderful lawyers who practice in a variety of areas. So I actually reached out to some of those family lawyers and mediators to, number one, ask, do you use this? And to my surprise, I was told yes. So then I preface this by saying, I'm one of those egg-headed academics, so please excuse the question I'm about to ask you, but why? And the answer from the lawyers was, there are judges to whom we have to bring these cases who really don't know anything about family law. And we would like them to keep their hands off of the settlement agreements that have been reached. Or they are judges with very idiosyncratic ideas about what it means to raise a child in the way that you should. And again, we want to protect the parents' agreements from these sort of meddling, intrusive judges. So it was an interesting response from them. And then when I talked to mediators who offer this and who I know to be really good mediators, they said, what you should know is I'm not one of those mediators who does it in a half an hour. I'm someone who does ask a series of questions in order to be sure that the parents really do know what they're entering into. So that's great. There is nothing in the statute that requires that. Nothing. There is no sort of certification or anything that has to be made by a mediator regarding what they engaged in before they rubber stamped the negotiated settlement agreement. I'll return to that in a bit when we talk about both benefits and problems and also about potential proposals to address this. So let me go on to discuss some of the other stories of opportunistic distortion. These other stories, they don't have as good names. So that's why I started with drive-by mediation. So I would assume probably that many of you are aware that California also has been a real leader in the development of mediation and dispute resolution in general. And in 1993, the California legislature actually passed a comprehensive scheme to encourage the use of mediation. The story I'm about to tell in connection with California is not limited to the family area in the way that that first story of drive-by mediation is. Several years later, in 1997, the legislature adopted a new chapter in its evidence code, and one of those provisions makes mediation communications undiscoverable, inadmissible, and confidential. There's been a whole series of cases in California in which parties have litigated what it means to make mediation communications undiscoverable, inadmissible, and confidential. And over the years, the California Supreme Court has really created a situation in which mediation, you can sort of imagine mediation as a bell jar, which preserves the inadmissibility of communications occurring during the mediation. It's been very strict protection of that inadmissibility. And normally I would call that mediation privilege, and it's very likely I'm going to refer to it at some points here as mediation privilege. It's not exactly the same thing as a privilege in California, but with the same effect, keeping mediation communications from being admissible in an adjudicative proceeding as well as being undiscoverable. In 2011, the California Supreme Court heard the case of Cassell versus Superior Court of Los Angeles. What is that case? That's a case in which a client had entered into mediation. He was represented by counsel and came to a settlement agreement. Great. What's controversial about that? After entering into the settlement agreement, the client then sued his lawyers for basically legal malpractice and a variety of other related claims. The question was whether or not the communications that the lawyers had with their client during the mediation could be admissible. His claims were based on things like claiming that his lawyers had really browbeat him into settling the case, that the lawyers had made promises about what they were going to do, in mediation that they then did not follow up on. He claimed that they had actually followed him into the men's room and browbeat him there in order to force him into settlement. Variety of allegations regarding what the lawyers had done in mediation. When the lawyers who were defendants in the lawsuit received the complaint and responded, they then filed a motion in limine with the trial court, asking the trial court to not permit the admission or even the discoverability of any of these alleged statements that occurred during the mediation. The trial judge granted the motion in limine, which then meant that the client really had no basis upon which to prove up his claims. On appeal, the appellate court reversed, basically saying, no, we do need to allow a client to be able to bring this claim and make these allegations and be able to introduce evidence supporting the allegations. California Supreme Court reversed and decided that no, the California Evidentiary Code says that all mediation communications are undiscoverable and inadmissible and confidential, and therefore this client is not going to be able to conduct discovery or to be able to present into evidence anything regarding mediation communications. That basically removed from the client the ability to bring the legal malpractice claim. It also essentially sent the message to lawyers in California or anyone mediating, any lawyer mediating in California, that they had a shield from legal malpractice claims if they settled cases in mediation. Now, interestingly, one of the things that the California Supreme Court included in their opinion was the speculation that perhaps California legislators knew that this would shield lawyers, but thought that there was a need for lawyers to be shielded in order to be able to have really frank conversations with their clients during the mediation process, and that maybe lawyers would only be willing to have those kinds of frank conversations if they knew they had this kind of protection. Total speculation. I don't believe there's anything in the legislative record that supports that. After the Cassell case was decided by the California Supreme Court, the California legislature directed its Law Revision Commission to conduct research about what was going on with mediation privilege around the country and to ultimately make a recommendation regarding revision of California law regarding, quote, the competing interests between confidentiality and accountability. In 2018, the commission came back to the legislature with its proposal. Actually, I think they came back in 2017. In 2018, the California legislature rejected what that proposal had been, which was to create an exception to mediation confidentiality to hold lawyers accountable while also allowing lawyers to rebut misconduct claims. Why did the California legislature reject that recommendation, that really very targeted recommendation? Well, for one thing, they got a lot of lobbying by mediators and also by lawyers and also by parties, all wanting to preserve this very strict mediation privilege that exists in California. The legislature did do something. They adopted an amendment that requires lawyers to advise clients in writing regarding the confidentiality that is provided by mediation. And they are required to get the client's written acknowledgement of receipt of that information in writing. Now, If a lawyer fails to provide that information in writing, if they fail to get the client's written consent, does that in and of itself represent a basis for attorney misconduct? I don't think so. Does it serve as a basis for undoing the settlement that has been reached? No, it does not. It is simply an additional requirement that is included in the legislation. I will say that very recently, because of some other cases that have arisen in California, there is some additional action that is occurring in California, providing for the potential disclosure of mediation communications, but that's only in disciplinary proceedings against mediators, and it's disciplinary proceedings, not malpractice cases, and there still is nothing that really would allow mediation communications to be introduced into evidence if there is a legal malpractice claim being brought against attorneys. Have there been any other cases in which clients who have settled their cases in mediation have alleged legal malpractice? Yes, there have been other cases since Cassell, and in those cases, the courts have followed the precedent that has been set by Cassell and have not allowed the admissibility of mediation communications. That's mediation as a shield from legal malpractice suits in California. Does this represent, by the way, another example of opportunistic distortion? Yeah, for sure. What was the privilege that was being granted by the legislature? The privilege was mediation confidentiality, protection from admissibility. In what way has that been used opportunistically to protect lawyers from legal malpractice claims when they help clients settle cases in mediation? Rogue mediation, another pretty darn good name, rogue mediation. And this is something that has occurred in Hong Kong and has some elements that relate to the litigation in the United States regarding good faith participation in mediation. In Hong Kong, courts there also have the ability to order parties to participate in mediation. And courts have engaged in that. They have ordered that participation. There have been parties in Hong Kong, as in the United States, that have really not wanted to participate in mediation. So what have they done? They have gone to the offices of the person who's been designated as the mediator. The mediator has immediately put them into separate rooms. They have not spoken to each other. They have not engaged in anything even approaching mediation. But then after 30 minutes, the mediator declares the mediation has been unsuccessful and provides them with the documentation that is required, the declaration of unsuccessful mediation, which then entitles them to the issuance of a mediation certificate and permits them to go back into the usual court proceedings. There are ways in which this seems a little bit like all of the controversies over good faith participation in mediation. But a lot of times in the United States, when that has occurred, it's been one party who has wanted to mediate and the other party has not wanted to mediate and has not really participated in good faith. And then there has been litigation over that. That hasn't really challenged the definition of mediation or whether mediation occurred, in my view. Still, the mediator has attempted to facilitate communication and negotiation between the parties. It's just one of the parties didn't want to negotiate. What's unusual about rogue mediation and why I'm calling it another opportunistic distortion is that as a result of courts ordering parties into mediation and then the parties collusion with each other and then collusion with the mediation provider, there then is something that is really just, it's nothing. It's not even negotiation, it's nothing. But then is being called mediation in order to meet the requirements of the court. In Hong Kong, the court responded actually unhappily and required the bar to direct the lawyers to not be doing this kind of thing. So the court actually took this on very directly, but more recently there have been revisions to the court rule that suggest to me that this kind of distortion could occur again. One last story of opportunistic distortion, and this is the story of binding mediation. Now you might ask yourself, because I did, what the heck is binding mediation? Does it just mean that you will be bound by the mediated settlement agreement that you reach? No, no. In binding mediation, parties initially mediate, but then they have agreed beforehand that if they are not able to reach a mediated settlement agreement on their own, then the mediator will have the power and the authority to decide any issues that remain unresolved at the end of what I would call the mediation. Does that mean that the mediator is then going to hold a hearing and sort of turn this into a med-arb process that would begin with mediation and then end with arbitration? No. There is no requirement of any kind of an additional hearing. So what does that mean? It means that a mediator hold a mediation, could conduct the mediation entirely in caucus. If the parties are unable to reach an agreement, the mediator then may issue an award, the mediator's binding award, and that could be based entirely on what the mediator heard from each of the parties individually in caucus. Now, as you and I think about that for a second, does that raise any concerns? It raises concerns for me because I don't know if I'm one of the parties, I don't know what the mediator heard about me or about what I've done or about the situation when the mediator was in caucus with the other party. So I have no ability to contest what was potentially heard. And I am less likely, in a sense, to share with the mediator what might be useful information in terms of settlement if I know that the mediator has the ultimate power to issue an award that will be binding upon me. All right, binding mediation. I hope that as I've described this, you've thought to yourself, well, mediation, that's supposed to be a consensual procedure. Doesn't this kind of turn into an adjudicative procedure? Isn't that what binding mediation is? Isn't that like automatically inconsistent with the definition of mediation? Because after all, one of those elements of mediation was that there will be a settlement reached that's voluntarily reached by the parties. Therefore, you probably would assume that courts have never been willing to enter judgment on a binding mediation award, and you might assume that courts have not been willing to enforce clauses calling for binding mediation, and you would be wrong. In California, again, this came up for the first time in 2006. In that case, interestingly enough, the court actually did refuse to enforce an award, the mediator's award. The court found that the clause calling for binding mediation was, at the very least, confusing, that it would require a court to come up with new rules for this hybrid procedure, which was neither mediation nor arbitration. That ADR, which was supposed to help the courts to streamline their dockets, if allowed to morph into binding mediation, would actually require more time from the courts as they came up with customized rules. And one of the judges, in a concurring opinion, blasted this process, calling it ridiculously oxymoronic, and a process that actually would discourage parties from settling their cases because lawyers would be unwilling to make disclosures during the mediation process if they knew the mediator had the power to actually issue an award. That was in 2006. 1 year later, in 2007, another California court actually enforced the award that had been issued by a mediator, finding that the complaining party was stopped from complaining about it due to her acceptance of this procedural mechanism in a contract. This court did not find it confusing. In 2012, a court again enforced the award that had been issued by a mediator, finding that there were sophisticated parties involved who knew what they had signed up for. These were parties that claimed that they should have had a hearing. The court said, there was no hearing in a binding mediation and you didn't provide for it. You're stuck with what you arranged for, you contracted for. In 2018, in another case, the court enforced a provision for binding mediation in a settlement agreement. So in California at this point, it looks like binding mediation is enforceable, both in terms of the enforcement of the award and enforcement of a clause providing for binding mediation. There are other states also that have dealt with binding mediation, either one of the parties objecting to the enforcement of an award or parties objecting to the enforcement of a clause in a contract. There are not as many cases, though, in those other states. And in the states, and in some of the states anyway, that have had to deal with this, it's arisen actually in the context of judicial procedures where you actually have a litigated matter in which the judge responsible for the matter then engaged in judicial mediation, or in binding mediation pursuant to local court rules. In those cases where it's a judge who has been doing it within the context of litigation, courts have not enforced those binding mediation awards. But when parties have entered into binding mediation as a result of contract in California, it's been enforceable. All right. Time for another little conversation. Do these represent examples in your view? Are these mediations, examples of mediations? I mean, I guess I would say, yeah, in California where mediation is being used as a shield from legal malpractice, that's still mediation. But do these also represent opportunistic distortions of the process or misuses of the process? Again, if you could raise your hand, or Nikki, if there is some response in chat, please feel free to share it with me.
There have definitely been responses in the chat, but I do want to give people a chance to raise their hands. One of the questions is just a clearly kind of a procedural one: is do you have a list of the citations of the binding mediation California decisions?
Yeah, so I could provide it to you. The list is in a manuscript, and it would be easy enough for me just to add. I will be making available to the organizers these slides, and it would be easy enough for me just to add a slide that has a list of the cases that I've referenced on binding mediation for sure.
All right, I will kick it over to Jeremy, but nobody else be shy, please.
So the binding mediation is the one that intrigues me the most. I mean, I don't know about the others, but I think for me there's a kind of it's the vacuum. What happens if this is not mediation anymore, and then does this become arbitration or not? If the title is not there, so we go into a gap, kind of a zone of lack of clarity.
Correct.
And I'm just trying to work out, what would happen under the New York Convention, for example, if you were to simply go and ask for, and the real issue is this going to be automatically enforceable either in another state or overseas.
Yeah.
And then you've got to start bringing in, I think, well, either domestic provisions or the New York Convention for the international aspects. And so forgive me for thinking too much like a lawyer, but let's assume for a moment that the parties had agreed to this, not only in their original agreement, but that everything was done in caucus. And they agreed at one stage that, look, we're still stuck. We trust you enough. You just tell us, because we need to get this over. The pain of continuing this dispute is too great for us. Just please issue your award now. We're not going to bother to appoint you as an arbitrator. We don't want to go through the formalities. We don't know how to do that. We just want you to issue a binding award.
Yeah.
And we don't need to have a hearing. You don't need to have due process. You don't need to tell us anything that happened in caucus. At the end of the day, we just trust you to use your good judgment in an equitable basis. And, so for me, that might still be an acceptable possibility. That's what the parties genuinely want. The problem I would have is that if you just went on the basis of an original agreement to permit this, I would have difficulty because you don't know what happened during caucus.
Yeah.
And so does it make a difference, first of all, if a waiver is signed at this stage? Does binding mediation become acceptable if at the moment that the mediator, is going to act as a quasi-arbitrator and issue an award, the parties then signed a waiver?
Yeah.
Or do you still need to deal from a due process perspective with information in caucus, either requiring that information to be divulged so that there's an opportunity for a hearing on the topic, or the party or they agree that the arbitrator undertakes to not include it in making the decision? So I'm just, or you can just leave it because the waiver covers all of it. So I'm not troubled with the idea of binding mediation if it's done properly and these last three issues are sorted out.
So once again, Jeremy, wonderful points. And notice that I think pretty much all the more nuanced points that you're raising are also issues that arise when we're talking about Mead-Arb, right? But at least with Mead-Arb,
there's an arb
clearly being identified as arbitration, right? Exactly. All right. So let me just say, first of all, so all of those issues of at what point should a waiver occur? What kind of information needs to be provided? How much informed consent? Should there be some specific agreement regarding whether or not the mediator will keep confidential what was said during caucus? All that stuff, all of that. I think is really legitimate and is also raised in the context of Mead-Arb. I'm going to set that aside for a second, probably more than a second, because this process is not being called Mead-Arb, it's being called binding mediation. And in a way, so I haven't actually included this in the article yet. I might based on this conversation. In a way, I think it'd be so much cleaner if a binding mediation clause is never enforced because it's called mediation, right? If instead, but if it looks exactly the same, but it's called Mead-Arb, with all of what we know about what should be included in order to ensure informed consent regarding Mead-Arb, I think I still don't really like it when you have a single neutral conducting a Mead-Arb process for all the reasons I'm sure you can anticipate, but at least we would know what we were talking about. I hate, personally, that the term mediation is being used for an adjudicative procedure. I hate it.
But again, if you just go back to the definition, if you accept the definition that mediation is a facilitated negotiation with the help of a trusted neutral, it still remains within the confines of that definition.
I don't think so, because the final part of the definition is and results in the voluntary agreement of the parties. Now, maybe you're saying resulting in the voluntary procedural agreement.
I didn't add that phrase. It's simply reaching a negotiated agreement with the help of a third party. That doesn't require that the final outcome actually be a mutually acceptable one. because you can bring in elements of
Yeah.
adjudication and even into a mediation. I mean, it's happened to me in mediations that you said, okay, we don't agree on the value of the real estate. Let's bring an expert in. Do you both agree to be bound by that decision? You know, it's like
Yeah.
a soft little mini arbitration. They say
Yeah.
yes. The
Yeah.
experts come in, they give their answer, and you keep on going.
Yeah. So let me just say one other variation on this that presents greater nuance difficulty. I think well, let me just share it. So, and Jeremy, I would bet you're familiar with this because of international practice. What if the parties in mediation are unable to reach an agreement? They then turn to the mediator and say, we would like you to issue an award, but we want it to be an award that we have the ability to reject. And if we don't reject it within, let's say, 2 weeks, if neither one of us rejects it within 2 weeks, then we will be bound by it. I mean, that is a more sort of passive consent. It's not just procedural consent. It's not just consent to the authority of the mediator to issue a binding award. It is also essentially a passive consent to the award once it's been issued. I mean, I think you can see why I think at least today I'm less uncomfortable with that
Well,
than with finding the other definition. Yeah.
and there's a gray area because we are saying in the absence of the word arbitration, we don't know how to deal with it. But there are in some countries the concept of adjudication, which is not arbitration.
Mhm.
Adjudication being subject to review, which
Mhm.
arbitration would not in the same way. And
Right.
people do accept the idea of adjudication without it becoming arbitration. So what you're basically describing in a way here is saying, we're going to mediate. If we can't agree, the mediator's going to swap hats, will become an adjudicator. We'll wait for 2 weeks, and then that is going to take on the strength of an arbitral award because nobody's challenged the adjudicator's ability. And so
Right.
we're, in a
Right.
way, elevating the status of the award and the neutral at that stage
Yeah.
to being an arbitrator
Yeah.
because we haven't
Yeah.
objected, which is the equivalent of giving a waiver at that stage.
Yeah. 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 All right. So this has been fascinating. And let's see if there's anyone else who has any comments regarding or questions regarding any of these other examples of what I'm calling opportunistic distortion.
There have been a lot of kind of one-word comments about misuse, misunderstanding, misappropriation of the process. Does anybody else want to chime in live? Yes, Richard.
Please go ahead, Richard. Yeah.
Thank you. I always get challenged as being a non-attorney when I ask questions about settlements, but here in Wisconsin, I'm familiar with a high-stakes case in which parties to a mediation were stopped from successfully having the discussions released down the road when a larger settlement was reached. And my question is, when it comes to malpractice, isn't there a way, and I don't know of a way, but couldn't there be a way for parties to confidentially safely release the discussions in chambers, so to speak, so that malpractice claims could be pursued? I'll stop there.
So yeah, so in many states, yes. In many states, the answer to that is yes. California is unusually strict in terms of protecting mediation communications. But in states, for example, that have adopted the Uniform Mediation Act, there is a specific exception to the mediation privilege for any claims of professional misconduct against lawyers or against mediators. So the Uniform Mediation Act absolutely provides an opportunity. In Texas, I'm going to use Texas as another example. If parties have reached a settlement agreement in mediation, But then there is, for example, a claim being brought by one of the parties against their lawyer for malpractice. In Texas, the court is permitted to admit evidence regarding mediation communications because of a common law doctrine that's been developed by Texas courts called the offensive use doctrine. Because that claim is not going to challenge to undo the settlement agreement, because it's distinct, it's an independent, it's a tort that's independent of the settlement agreement. Texas courts will admit into evidence mediation communications that will be relevant to determining whether or not there was legal malpractice. So that's another example. And I will say that the California Revision Commission, oh my gosh, they did an unbelievable job surveying the status of confidentiality and mediation privilege throughout the country. Their report is fantastic for anyone who wants to know what the state of the law was as of 2017. And they provided a lot of other alternatives that had been adopted by other states. So in response to your question, in most states, there would be a way to accomplish this, but in California, no. In a sense, I keep coming back to that bell jar, protecting everything that was said within mediation. Colonel Pratt.
Hi. So I do not have a legal background. But I think a point that actually Susan Levin brought up in her comment is something that needs to be highlighted more than it is.
Yeah.
And I think that fundamentally there is an incompatibility between a legal system that requires people to have an enormous amount of knowledge to navigate it well, and mediation that is built on principles that empower individuals in a process where there is, like Susan pointed out, self-determination. How can you have self-determination when you've introduced these adjustments to a process that didn't require people to be legal experts? They're not legal experts. So how are they self-determining anything when they've been disempowered of the knowledge of what is actually going on by, kind of playing, I don't know, just kind of the cup game with the terms.
I know what you're talking about. Yeah.
Do the participants have a clear understanding of what they are getting into with these alternatives and what they are giving up, because they clearly understand what mediation is? And I don't know if in any of these examples that you can say, yes, the participants clearly understood.
So I would say, I think you're raising a very good point regarding to the degree to which people engaging in mediation, regular old people engaging in mediation, really are doing that in an informed way, and whether we can assume either that they are exercising informed consent when they are agreeing to one of these procedures that I've highlighted here, or when they are agreeing to a particular settlement. I think that's, I believe in the field of mediation, that's part of the dark underbelly of mediation, that we are advocates for the process, but we don't always work as hard to ensure that regular old people, including self-represented litigants, of whom there are many, are really engaging in it with informed consent. I think I'm going to say a tiny bit more about that later on in the presentation. I will try to remember to do that. So because of time, Wait, is it possible that it's 4 minutes to 10? Oh my gosh. All right. So I'm not going to allow as much conversation for a little while. I'm going to drone on, and hopefully you'll find it interesting. I want to get to the conclusion, before it's 10 o'clock. Okay. I promised I would talk about the Singapore Convention. I'm sure many of you are aware, well, I hope many of you are aware, that in 2018, late 2018, the UN General Assembly actually ratified the Singapore Convention. This is a convention that has been signed now by 58 nations, including the US. It's been ratified by 15. The US has not yet ratified it. What does the Singapore Convention do? Well, most importantly, what it does, it provides for expedited enforcement of mediated settlement agreements. So, a mediated settlement agreement is a contract, right? What if one of the parties refuses to comply with that contract? Well, traditionally, you would need to bring a new action, a breach of contract action, and then you would have to prove up the contract, and then you would have to get the court to enforce the contract, enforce the mediated settlement agreement. There are other requirements in other countries as well. Those countries that have ratified the Singapore Convention have agreed to expedited enforcement of settlement agreements, but only if they're mediated, not if they are negotiated, only if they're mediated. Why the exception for mediation rather than negotiation? Because the delegates heard information about all the ways in which mediation is regulated in a variety of states. And so they ended up concluding that mediation, if settlement agreement was mediated, it was entitled to more deference than if it was a negotiated settlement agreement. But here's the definition of mediation in the Singapore Convention: a process whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person or persons, the mediator, lacking authority to impose a solution upon the parties to the dispute. Are you noticing some words that are missing? Nothing here about impartiality, nothing here about facilitating communication or negotiation. It's just some kind of assistance. There was discussion among the delegates about whether the parties to a mediation might go to a pub and ask somebody in the pub to help them facilitate their discussion and help them come to a mediated settlement agreement. And the answer was, yeah, if that happened, if there was mediation in a pub, as you're describing it, yes, that would be entitled to expedited enforcement under the Singapore Convention, despite the fact that they also talked about how valuable the regulation of mediation was in various countries. Is it possible to avoid the enforcement of a mediated settlement agreement? Yeah, it is possible. There are defenses that are available. If you can allege that the mediator breached a standard of conduct or failed to make a disclosure that they should have made. But the showing that also has to be made is that the party would not have entered into that agreement but for the mediator's breach of standards. That's a really high showing to make. Is this the kind of definition and the kind of expedited enforcement regime that could encourage the adoption of drive-by mediation in this context? Oh, yes, for sure. I absolutely can see how parties involved in a dispute internationally could negotiate to a resolution, call a mediator, spend 30 minutes with them, and end up with a mediated settlement agreement. Absolutely, I can. And as Jeremy noted earlier, that same sort of subterfuge occurs within international commercial arbitration pretty commonly, where an arbitrator will have a case, but then the parties will go off and either negotiate a resolution themselves or mediate a resolution, bring it back to the arbitrator. The arbitrator will convert, that's what it's called, convert the mediated settlement agreement into an arbitral award, and then it will be enforceable under the New York Convention. Here, could a negotiated settlement agreement be converted into a mediated settlement agreement and therefore enforceable under the Singapore Convention? I think there's no doubt about it. But here's what's important. The Singapore Convention does not apply to the kinds of cases involving regular old people, at least most regular old people. It doesn't apply to consumer, family, inheritance, employment cases. It's meant to apply to cases involving international commercial disputes and, in general, sophisticated parties. Will they always be sophisticated parties? Not always, but more likely in that context than in consumer, family, inheritance, or employment. I just want to say, all these different, what I'm describing as distortions, who's benefited by this? Here's the biggest point to make. We talk a lot about self-determination. If the parents have come up with what they think really works for their kids, and they're managing to avoid interference by a meddlesome judge, does that represent an exercise of self-determination? Arguably, yes. If parties really want to hear frank talk from their lawyers, then, it could be that the mediation privilege that California has it also represents an exercise of self-determination. If commercial parties want to guarantee that their negotiated settlement agreement is going to be enforced and will be enforced quickly, well, then this represents an exercise of self-determination. So arguably every one of the distortions I've described has the potential to represent the party's exercise of self-determination, even binding mediation. But are there problems with every single one of these? You can tell that I think there are problems, and it sounds like a number of you think there are problems. Drive-by mediation. Shouldn't somebody be looking to be sure the best interests of the children are being met? Shouldn't somebody be looking to make sure there's no child abuse that is going on? Shouldn't somebody be ensuring that the parties who had their lawyers negotiate on their behalf, they really do understand what is going on in the agreement that they have signed? Shouldn't somebody be making sure that in binding mediation that the parties know that a mediator could be making a decision based on what they learned in caucus, an uncontested piece of information they learned in caucus? Shouldn't somebody be concerned about the integrity of the field? And shouldn't the courts be concerned that if they are sending parties into these kinds of procedures with these kinds of dangers, that it also challenges the integrity of the courts? So what are some potential responses? I got to say that one potential response is, who cares? Let's do nothing about this. All of these represent new opportunities for mediators to get more business. That's pretty cynical, what I've just listed as an item, but I think it's out there. Another possible response. Maybe in these cases where special privileges or benefits are being granted to the use of mediation, there should also be clearer, more precise, more demanding definitions, as well as some duties for mediators. The duty, for example, to certify that they actually did engage in facilitation of communication and negotiation, that they did ensure that they had made certain disclosures. Maybe even in cases involving self-represented litigants, like in debt collection, eviction, foreclosure, in those kinds of cases, maybe even mediator certification that the result is not unconscionable. That's a lot lower standard than fair, but not unconscionable. Maybe there should be additional substantive protections that are provided in these contexts involving unsophisticated self-represented parties. Maybe a judge should never be unable to look at the best interests of children. Maybe we should never allow professionals like lawyers or those with fiduciary duties to be able to use mediation to avoid malpractice claims. The most extreme response is to say, you know what, mediation, we can take off the training wheels. All of these privileges and benefits were introduced in order to encourage the use of mediation at a time when mediation was not well known. mediation is being used all over the place now. Mediation is being used in all different kinds of cases. Maybe mediation no longer needs these sorts of special privileges that invite opportunistic distortion. Maybe it's time to revoke the special privileges and benefits that are being granted to mediation, especially because we now know we can't guarantee that the description of mediation that was used to gain those special privileges and benefits, we can't guarantee that that's what those mediations look like. That's my most extreme, and I gotta say, my saddest proposal that is included in a manuscript that will be published. With that, I come to the end. I have this special slide that says, looking forward to your feedback and questions. And I realize now that I've gone over time. So I apologize in advance for that. And I invite any other questions or comments that you might want to send my way. You can find me through the Texas A&M University School of Law website. And as I said, I will be providing these slides to the organizers. And with that, Nikki and Maria, I send it back to you and apologize again for going over time.
Great. We are past the 10 o'clock limit. Maria, do you want to say a few words other than just thank you, thank you, thank you? And in addition to the robust verbal engagement, there has been a lot of insightful comments and questions in the chat as well.
Yeah, I just want to echo Nikki's thank you to you, Nancy. This has been absolutely wonderful. It's been stimulating. It's been thought-provoking, and I think everyone's going to leave here with a lot more thoughts about the uses of mediation in interesting ways. We are at that 10 o'clock point where we do turn off the recording. If you can stay on for a few minutes, but we promise always that we're going to turn off the entire Zoom call by about 10:15. If anyone has any last thoughts or questions, we'll be here for a few more minutes, but Nikki, can you turn off the recording?
Yes, thank you so much, and tune in next month. Hope to see everybody then.
Yeah.